In rejecting the SEC's claims that Solarwinds should have updated its disclosures to reflect two specific cyber incidents, Judge Engelmeyer noted that the SEC's case rested too heavily on quote-unquote hindsight and speculation, because the evidence established that Solarwinds' disclosure was made at the time in the quote early stage of its investigation, close quote, of these incidents. Judge Engelmeyer also rejected the SEC's post-Sunburst attack claims of fraud and false filing claims based on SolarWinds' Form 8Ks, in which it disclosed the Sunburst attack. The court ruled that, quote, the SEC does not plead with particularity that the Form 8K, which by any measure bluntly reported brutally bad news for SolarWinds, was misleading for not disclosing two prior incidents. Silence absent a duty to disclose is not misleading, and disclosure of information is not required simply because it may be relevant or of interest to a reasonable investor.
Global companies face unprecedented risks and challenges in today's economy. To mitigate these legal and economic risks, companies are rapidly embracing and elevating the importance of robust ethics and compliance programs to promote positive corporate citizenship. On Corruption, Crime, and Compliance, you'll hear from industry leaders and insiders about how to create effective ethics and compliance programs that will mitigate risks and maximize financial performance. Here's your host, Michael Volkov.
Well, hello, everyone. Michael Volkov here, Corruption, Crime, and Compliance, another episode. Today, we're going to talk about the SEC's really suffering a major blow in a securities fraud case against SolarWinds and the implications. Thanks for joining me today from beautiful Del Mar, California. It's gorgeous. Hope you're enjoying your summer. And this is another interesting case as we see cyber attacks and cyber risks and cyber disclosure requirements coming up. From the SEC standpoint, this was a major case decision. Obviously, it will be appealed. But let's talk about it because a New York federal district judge handed down a significant decision dismissing much of the SEC's securities fraud enforcement action against SolarWinds arising from its claims related to SolarWinds' cybersecurity policies and disclosure of a significant attack against the SolarWinds network. In an unprecedented case, the SEC alleged that SolarWinds, which went public in 2018, misled the public as to the effectiveness of its cybersecurity practices and products, including its flagship Orion software platform. In a security statement on its website and in a variety of other public statements, including securities filings, the SEC argued that SolarWinds filings were misleading because SolarWinds failed to disclose that its products and practices were defective in protecting against cyber attacks. The SEC contended that the company's hype misled the investing public to believe that SolarWinds' central software product had minimal vulnerability to attacks. Also, the SEC alleged that SolarWinds misled the investing public about a series of cyber attacks which culminated in the revelation in December 2020 that the company and its customers had been victims of a large-scale cyber attack known as Sunburst, which was conducted by Russian hackers. The SEC claimed that in the aftermath of Sunburst's immediate attack, SolarWinds minimized the scope and severity of the attack, including by omitting that customers had previously reported similarly malicious activity involving the Orion product. So here, District Judge Paul Engelmeyer, and as to the first claim, we'll go through the claims that he considered and those that he dismissed and those that he preserved. The first claim, the pre-Sunburst disclosures contained in the security statement, U.S. District Judge Paul Engelmeyer upheld the charges because the violation is, quote, viably pled as materially false and misleading in numerous respects, close quote. With respect to the second claim, the post-Sunburst disclosures, Judge Engelmeyer dismissed all of the claims because the SEC did not, quote, plausibly plead actionable deficiencies in the company's reporting of the cybersecurity hack. Found that the SEC claims, quote, impermissibly relied on hindsight and speculation, close quote. Finally, the court dismissed all SEC claims that SolarWinds' internal accounting and disclosure controls were ill-pled as applies to its cybersecurity controls. Now, the impact of this part of the decision is significant because this is the court saying that the internal controls provisions of the Securities and Exchange Act do not apply to cybersecurity's policies and procedures. And this is contrary to the position that was taken by the SEC in a settlement with R.R. Donnelley, which we had as a prior podcast episode, in which the SEC pushed the issue of internal controls and argued that they secured a settlement claiming that part of the violation was R.R. Donnelley's weakness and deficiencies in its internal accounting controls relating to its cybersecurity policies and procedures. So we now have a district court decision which goes contrary to the SEC, and we have the SEC with a 3-2 commission vote, taking the opposite position that cybersecurity internal controls, cybersecurity policies are part of your internal accounting controls. The SEC's case, going back to SolarWinds, which was filed last year, alleges that SolarWinds knew as early as 2017 that its cybersecurity practices were well below industry standards, but issued various statements reassuring customers and investors that its cybersecurity practices were acceptable. In upholding the SEC's case challenging SolarWinds' security statement, the court found that the statement, quote, misleadingly touted SolarWinds' access controls as strong, close quote. In fact, as the SEC alleged, SolarWinds was well aware of deficiencies and weaknesses in its cybersecurity controls. In particular, the court cited evidence establishing that SolarWinds officials were well aware of deficiencies in its access controls, and at the time SolarWinds went public, these glaring omissions were known by numerous officials and employees in the company. The security statement also misrepresented SolarWinds' statements to the public that SolarWinds enforced a strong password policy. In fact, the SEC alleged that SolarWinds' stated password policy was generally not enforced. Instead, employees routinely use simple, unencrypted passwords with respect to products and internal systems, compounding SolarWinds' vulnerability to intrusion by threat actors. Now let's talk about SolarWinds' S1, their IPO filing, and their cybersecurity disclosures. The court rejected the SEC's claims that SolarWinds' Form S1 cybersecurity disclosures were deficient. As the court found, quote, viewed in totality, this risk disclosure was sufficient to alert the investing public of the types and nature of cybersecurity risks SolarWinds faced and the grave consequences that these could present for the company's financial health and future. The court noted that, quote, SolarWinds' cybersecurity risk disclosure, reproduced in full above, enumerated in stark and dire terms the risks the company faced were its cybersecurity measures to fail. Although a reasonable investor could easily have been led astray by the security statement, which was separate and on its website, such an investor could not have been misled by the risk disclosure. In rejecting the SEC's claims that SolarWinds should have updated its disclosures to reflect two specific cyber incidents, Judge Engelmeyer noted that the SEC's case rested too heavily on quote-unquote hindsight and speculation. Because the evidence established that SolarWinds' disclosure was made at the time in the, quote, early stage of its investigation, close quote, of these incidents. Judge Engelmeyer also rejected the SEC's post-Sunburst attack claims of fraud and false filing claims based on SolarWinds' Form 8Ks, in which it disclosed the Sunburst attack. The court ruled that, quote, the SEC does not plead with particularity that the Form 8K, which by any measure bluntly reported brutally bad news for SolarWinds, was misleading for not disclosing two prior incidents. Silence absent a duty to disclose is not misleading, and disclosure of information is not required simply because it may be relevant or of interest to a reasonable investor. Now let's talk about the last issue, which I had highlighted before, about internal accounting controls and cybersecurity policies and procedures. In dismissing the SEC's internal controls claims, the SEC's first reliance on the internal controls provision based on SolarWinds' cybersecurity failures the district judge rejected use of the internal controls provision to a company's cybersecurities controls under the securities laws. And I'm going to read the quote here because it's an important quote from the court. As a matter of statutory construction, that reading, being the SEC's reading, is not tenable. In various respects, the text of the statute strongly supports that the term system of internal accounting controls, in quotes, instead refers to a company's financial accounting. The term accounting is widely defined in this manner, for example, as the system of recording and summarizing business and financial transactions and analyzing, verifying, and reporting the results. Merriam-Webster's dictionary was cited for its accounting definition. The SEC, the court says, has not identified any dictionary definition favoring its construction. And the surrounding terms that Congress used in Section 13B2B, which refer, among other things, to transactions, preparation of financial statements, generally accepted accounting principles, and books and records, are uniformly consistent with financial accounting. So the court's decision is the first on this topic, and probably not the last. The SEC's expansive use of its internal controls provision for non-financial accounting purposes is a significant limitation to the SEC's application of this important provision used in the enforcement of securities laws. It now could have implications for FCPA enforcement and other types of fraud concerns where it's not directly related to the accounting controls. Anyways, should be interesting. We'll keep tabs on that issue, and the SEC is going to have some interesting appeals and some interesting litigation coming up in this area. Well, thanks everybody for listening. Hope to see you next week for another episode of Corruption, Crime, and Compliance.
If you enjoyed this episode, the best way to support the show is by subscribing on your favorite listening platform. To learn more and connect with Michael Volkov, go to volkovlaw.com.